is fall here in California, which is super exciting to me. It's sweater weather. That means it's like 60 degrees out, 65. It's awesome. Okay, today we're going to go back and we'll go back to the basics. We're talking about legal analysis. This is what we learned in law school. But did we really learn it? I would posit that a lot of people didn't really learn it. Okay, so let's do a quick review. We're talking about the order of operations of legal writing according to Brooke. We start with our vision. What do we want from the brief that we're writing? What is the purpose of it? Where are we going? What do we truly want? What's our ask? What do we want to happen? Second step is we need to know our evidence and the facts upon which we're going to build the foundation that's going to grow into this thing that we want. This third is your attorney declaration. I've done videos on all these things before, and then after that you start writing the brief. You start with the statement of facts, procedural history, what's alleged, that sort of thing, what the evidence shows. And then you do your outline of legal arguments. And as you're doing that, that's when you're researching, you're putting your outline, you're figuring out the structure of your brief, and you're in the process, you're inserting your statements of law. So now you're ready to do the analysis. So you've got your outline and your structure, and you're going to pick one section at a time, and you're going to do the full analysis in each section. And then at the end, you go back and polish it up. So legal analysis. Like I said, this is one of the first things we learned in law school, and we get so good at it as lawyers. We do it so quickly in our heads. We hear the rule, we hear the facts, like they get together and do a little dance in our brain, and we know what the answer is or should be. But that doesn't work for legal writing. You can't just say, here's the law and here's the facts. Obviously we win, judge. Like, that's not how it's going to work. So legal writing is the art of slowing down that process, that analysis process that speeds through our brains as lawyers. Explaining the application of a legal rule to a set of facts in a way that clarifies for the court why we win, why the court should give us the relief that we're asking for. All right, so when there's not really anything to do but just be methodical in going through each element and the facts that show each thing. So when performing analysis, you have to write down things that seem obvious, right? So we're showing, not telling. It may seem obvious to us, and sometimes I write down things and I'm like, this is the most obvious thing, but once you go back and think about it, like, you need it. It's like laying a pathway. Okay, let's go back to math. We're showing our work, right? We have to write down each step as we go through it, and then that's a thing that a roadmap for the court. They can go through and say, okay, here's this, here's how they showed this, here's how they showed this. Now there's no foundational cracks, and there's no way to argue anything other than this. And this is important for that reason, because we want to leave a roadmap for the court, a pathway for them to easily follow and get to the destination we want them to get to. But it's also really important when you're writing a brief that somebody may oppose, right? Because when you're opposing a motion, it's much easier to argue, hey, those guys didn't say what they needed to say. Those guys didn't do the analysis. They didn't show you the facts. They just argued. They just made an argument. They didn't actually show their work. It's much easier to pose that and say, they're asking for a thing and they can't even tell you why they want it. It's much easier to make that argument than it is to say, look, they took you on this path, but along the way, they jigged right when they should have jigged left. You know, they made a mistake or they miscalculated. And in the brief, that looks like distinguishing cases, right? So you're saying, okay, they relied on this case, but that case doesn't say what they think it says. It actually says this. And the part that they're quoting is from dicta, or it is from a part that is like related to a completely different issue than what we're talking about. The court's comments on this particular issue are this, and that's why we win. And so defense showed you that, like, you got to dig in, and it's a harder argument, and frankly, not usually a winning one. If they've done the work and their homework in building it up, then it's much harder to oppose. And you want to create that for the people who might oppose your motion, right? You want to create it in a way and write it in a way that makes it harder for them to oppose, that makes them have to spend a lot of time going in and digging in the case law to see if there's a way to distinguish it, and then coming up with whatever arguments they can come up with. So that's the analysis part. If you're bringing the motion at a base level, you can always use because statements. The plaintiff has met this element of causation because she's proved by Dr. X's testimony that her injury is directly related to the car accident. Okay, so you can use a because statement like that. You could say Dr. X's testimony is the evidence for causation. You could say that. As you grow and mature as a writer, you get to the points where you can say that without saying, we meet this element because. But that's a good way to start it out. Here's the rule. Here's my element. Here's the evidence that fits that rule. And therefore, we've met it because this fits into there. And I don't really know if this is like the appropriate place to say this, but I'm going to say it anyways because it's my biggest pet peeve in any brief that I'm reading or writing or proofreading or anything. I really, really hate it when someone says clearly or obviously or plainly. I hate those words because if it's so obvious and so plain, then you can just say it. You don't have to say the plaintiff is clearly right here. Don't say that. It's not effective, and it takes me right out of the train of thought that I had when reading the brief. It pulls me right out, and I'm just immediately it's like having to say, hey, I'm tall. We already know you're tall. We can see that. We can already tell we clearly win. We don't need you to say that word, and it's distracting, and it makes you seem insecure. And if you have to say we win because we win, then you're doing conclusory arguments anyways. So just don't use those words. Whenever I'm proofreading, I always do the first thing, even before I read anything, I just Control F, search for the word clearly. And if it's there, I highlight it and I put a big red flag by it. That's not an okay thing to do in a brief. You're better than that. So, okay, so we talked about analysis. Not the most scintillating topic, I know, but it's the most important part of your brief. Like, I put a lot of emphasis and I can talk colorfully about a lot of different parts of the brief, but this is really the meat and potatoes of your brief, and it's the thing that the court needs to be able to easily digest. So I'm full of the metaphors today. Show your work. Show, don't tell. That's it. Have a good day. Make it a good day.